Why would a judge make a ruling that is unconstitutional? Recently, I made a video about how to respond to a judge's ruling that you don't believe is constitutional. And a lot of people had some really strong words about how a judge should be handled if they issue an opinion that is later found to be unconstitutional. And of course, my question is, how do you know it's unconstitutional? Today, I would like you to go through a little exercise with me. I'm going to give you 3 Supreme Court cases and then a hypothetical. And I want you to be a district court judge and make a decision about how you would rule. And while you're doing it, I want you to think, is there any chance that this ruling, even though it follows the rules, could be overturned later as unconstitutional? Okay, let's get started. The cornerstone of this discussion is going to come from the First Amendment of the US Constitution, which forbids the government, among other things, from abridging the freedom of speech. But there are some situations where the government is allowed to abridge the freedom of speech, and one of those, according to the courts, has historically been in schools. Because schools are there to teach students, and if students were allowed to just say anything they want, anytime they want, it would be mayhem and no education would actually happen. Okay, so let's look at our 3 cases. Our first case is Tinker v. Des Moines, also known as the Black Armband case. Case was decided in 1969, but I think the action actually went down in 1967. May have been 1963. Regardless, a bunch of high school kids decided to protest the Vietnam War, and they did it by wearing black armbands to school. That was all. They didn't carry signs, they didn't do a sit-in, they didn't do a walkout, nothing like that. All they did was wear the armbands all day at school. It was a silent protest. And this made it a really good test case because there was no other information to consider. Now, the school was concerned that this could interrupt the school day and that it could cause fights or things like that. And apparently it did cause a couple of little skirmishes in the hallway, but nothing in the classroom. And really nothing major, apparently, like a couple words back and forth, and that was about it. But nonetheless, the school told the kids to take the armbands off. The kids refused. The school punished them. And the kids sued. Now remember, the district court sided with the school, and the Supreme Court overturned them. But that's not really why we're here. Now, the Supreme Court recognized that a school needs to keep order, and that there are certain times when a school needs to tell kids, you can't do this, you can't say this. When a school gets to stop kids from doing whatever they want. But very famously in this case, the court said that students do not shed their constitutional rights at the schoolhouse gate, meaning that the First Amendment still applies inside of the school. It just has to be balanced against the school's need to keep order. So how do they balance it? Well, the court said that the school's concern that there might be an interruption was not enough of a concern for them to override the kids' First Amendment rights. This was a silent protest. They weren't actually interrupting anything. Concern that there might be an interruption was just not enough. So Tinker v. Des Moines says that silent student protest inside of a school is constitutional and cannot be stopped by school officials. Okay, now case number 2. Cohen v. California is a very different First Amendment case. Cohen v. California is decided in 1971. I think of it as the F-off case. This guy, Mr. Cohen, who is over 18 years old, is walking down the street in California wearing a jacket that says F the draft, but it actually says the 4-letter word on it. He is arrested for violating some sort of obscenity law. He appeals his conviction, and the court says, no. You cannot arrest people just for putting 4-letter words on their clothing. The First Amendment protects an adult's ability to say whatever they want, and that includes 4-letter words. Okay, now these cases are gonna cross a little bit. Our last case is Bethel v. Fraser. Now, Bethel is decided in 1984. In Bethel, a 14-year-old kid named Matt Fraser stands up at the student council election speeches to give a speech in support of one of his buddies. And he gives a stupid 14-year-old speech. There are no 4-letter words, but the speech is a little blue. It includes classic 14-year-old lines like, he takes his point and pounds it in. So, Matt Fraser is suspended for giving an obscene speech. He sues, it makes it all the way to the Supreme Court. Now, the court cites both Cohen and Tinker in making this decision. And they discuss the fact, as they did in Tinker, that schools need to be able to keep some level of control, even though there is some level of First Amendment rights given to students that do not disappear when they cross the schoolhouse gate. But unlike Tinker, in this case, they decide, no, this kid's speech is not protected. The court says that the First Amendment protects a student's right to wear Tinker's armband, but not Cohen's jacket. Just because speech must be permitted by adults does not mean it is protected by students in school. Okay, so let's take a look at this real fast. Silent protest by students? Protected. Obscene language by adults? Protected. Obscene language by students? Not protected. Okay, now a hypothetical. In order to reduce variables, we're going to pretend that the draft is still going on. And a group of students shows up in school wearing black armbands that say F the draft. But twist, they do not say the 4-letter word, they say EFF, right on the armband. The kids are told to take them off and they refuse. The school suspends them. They sue the school. They are in front of you in district court. What do you do? Process these 3 cases and the facts in front of you and decide what your answer is going to be. But then I'd also like you to consider for just a moment that after you've made that decision, you've magically become a Supreme Court justice. Might you consider overturning your own decision, and why? Now, this is just an exercise because I wanted you guys to go through the process of interpreting law, kind of how common law works, and specifically how it works at the district court level. Judges at the higher court have a lot more flexibility to change things. District court judges really have to look at what the higher courts have already decided and just follow those rules. But you can see that the decision-making process is kind of fraught. And the hypo I gave you isn't super complicated. What if the bans had said the full 4-letter word? Consider that it's 2025 and we have some slightly different thoughts on those words than we did in 1986. But I'd really like to hear your responses, and I'd also like to hear if this was an interesting process for you, if you'd thought things through this way before. Thanks for watching, guys.